Well, hello and welcome to Polity Matters. My name is Ben Ratliff, and I'm joined by Jared Nelson and Scott Edberg and one of our fourth co-hosts, Fred Greco. Welcome, guys. Good to see you guys. Yeah, good. And so 35.7, did I say it right? 35.7 tells us what it looks like when witnesses are showing up. So witnesses shall be examined first by the party introducing them, then cross-examined by the opposite party, after which any member of the court or either party may put additional interrogatories. No question shall be put or answered except by permission of the moderator, subject to an appeal to the court. The court shall not permit questions frivolous or irrelevant to the charge at issue. So
that's something you don't see on Law and Order. The jury start asking questions.
And to be honest, I don't think in ordinary fashion you see this in a ecclesiastical trial either. You know, you don't see one party say, "Mr. Moderator, can I ask this?" "Thank you. I'm going to ask this." I think what's in here is an implied, if someone asks a question that's out of bounds, the moderator, even if the other party doesn't object, the moderator of his own authority can say, "Don't answer that. No, that's impermissible." You don't often see, in TV dramas, judges doing that. Mm-hmm. You normally in the adversarial process, you see the other party objecting. Here, the moderator of his own accord, can do that. And I think that it can also apply to an answer. So I've seen this in which a question was asked and the witness was giving an answer that was not responsive to the question, but was giving all kinds of other additional testimony. And the moderator warned the witness several times. And at the end of it, when the witness kept insisting on not answering the question, but giving other answers, the moderator dismissed the witness. And so the moderator does have that authority. Now, the answer is if the moderator's abusing his authority, the parties can appeal to the court as a whole. And then the court as a whole could overturn the moderator. Kind of like, a challenge to the chair in a parliamentary procedure.
I've only been a part of one trial, and the amount of times that you have to say, yes, you can answer that question is just like mind-numbing. Because a lot of questions are just like yes or no, very quick and serial. And the slow person in the room is the moderator trying to approve the questions as he's receiving the questions over and over and over and over again.
Yeah, if
this
you can
is
ever
probably
witness
a section that could use a slight edit because, I understand. I think what Scott's describing, we would say, is not really a good trial.
Yeah.
Where you're kind of step. You want the witness to be able to tell the story, to give their testimony. And I think the way I've described it and experienced it is a little bit more natural. It may not be the natural reading of the language, but I think it certainly is a little bit more natural of the way of doing it.
to Scott's point, the moderator definitely has to be on his toes, keeping up with every teeny tiny little detail, though. Perhaps much more so than just a normal presbytery meeting.
The parties will keep you on your toes.
Yeah.
Yeah, if you're a member of a presbytery and you know there's a trial that's going to happen, go watch it, even if you don't know a whole lot behind it, or you're like, I'm just going to skip that meeting. You need to do this because it'll be an education.
Yeah. Okay. 35.8. The oath or affirmation to a witness shall be administered by the moderator, and the following are like terms. Do you solemnly promise in the presence of God that you will declare the truth, the whole truth, and nothing but the truth, according to the best of your knowledge in the matter in which you are called to witness, as you shall answer it to the great judge of the living and the dead? If, however, at any time a witness should present himself before a court, who for conscientious reasons prefers to swear or affirm by any other manner, he should be allowed to do so. I have so many questions. I'm really curious what like terms may be chosen to be used instead of this one. So it's this shall be administered to by the moderator, or like terms. So it's not really a shall, is it? That they have to use these bolded words. Fred, come on, just help me out.
I think the way this gets picked up is you'll notice that every time there's an amendment offered to 35.1, there's a corollary or a parallel amendment offered to 35.8. Those two provisions go together.
Yeah.
And so the idea here is you could have someone who does not acknowledge the existence of God, but does believe there's a future state of rewards and punishments. And so this affirmation or oath really isn't applicable. So you'd need to have something similar. Do you, as you shall answer for it in a state after death or something like that. And I think, again, this is a court's discretion. You'd have, so for example, I don't know, for example, whether a Muslim would take this oath. They might want something slightly different. I don't know whether, a Buddhist or a Hinduist would take this oath, but they would have something maybe of similar import. And I think the key here is the oath of 35.8 needs to fit the requirements of 35.1.
Good.
That's how I would read it.
Yeah, very good. Yeah, that last thing you said is what everybody should grab onto. That's spot on. I was wondering if the people that don't believe in God but believe in a future state of rewards and punishments, are those the people that believe Jared's in charge of what happens after they die, or is it just maybe it's some other actual religion? But
well, remember, there are people that think that the universe, the creation is eternal, and that it's uncreated somehow. I don't want to get into logical inconsistency, but there are people that think that, creation somehow is not God, but it somehow governs our lives in eternity. They got bigger problems than testifying in a PCA court.
All right. Good. Everybody good? This is, I love it. We're cruising. 35, 9, 10, 11, and 12 all go together and have to do with testimony and how we record it and preserve it. It may not take a lot to comment on each of these, but we're just going to go one at a time because it would be obnoxious to read all of them in one go. So 35.9, all testimony shall be recorded, transcription, audio tape, videotape, or some other electronic means, and witnesses informed of such prior to testifying. Such recording becomes part of the record of the case. However, in order to be referenced in written or oral briefs, such recording must be transcribed and the transcription authenticated by the trial court. The Court of Final Appeal may assess the cost of transcription equitably among the parties. So, right off the bat, let's just ask the question, why is it important for us to preserve testimony? Is it not enough for the court present in the room to hear the testimony and make a determination?
No, because our rules of discipline allow for complaints and appeals.
Right.
And the only way that a higher court can review those matters is through a record of the case or through documentation. This goes along with our principle that an appeal up to a higher court does not mean the higher court tries it all over again and brings the witnesses in. That's important. A higher court has a limited review. It's not broad. So sometimes people think that if you don't like a result, you can just keep taking the case up, and you can't. What you can do is appeal and say there was an error, and the only way the higher court can see if there was an error is by looking at the record, the documents, including the testimony. And so the testimony needs to be preserved for that purpose. Now, I will say that in the amount of time that I have been an elder in the PCA, ruling and teaching, about 30 years, this provision has become so much easier to accomplish. In the olden days, you had to hire a court reporter.
Like Perry Mason.
Who would sit there with a little super typewriter that had like whole words in it, banging away and doing that. Now, you can, videotape the trial using dozens of software. And they all will do some kind of artificial intelligence transcription. Mm-hmm. And you can check that transcription with any number of dozens of other pieces of software to come up with a transcription. But that still needs to be authenticated by the court. And so someone needs to go through and make sure that it's actually accurate. And it can be done that way. And that can be very painstaking because you have to do that. But the expense of having a court reporter is not required like it used to be.
What happens in a case if a part of the record is lost? Like, let's say there's no transcription or recording of the trial that has been appealed up to the next higher court. What does the higher court do if they don't have that recording?
Well, I think the higher court would have to try to take some measures. For example, let's say that you have a 2-day trial and the testimony of one witness is lost somehow. I would think a higher court could ask both parties if that one person could give their testimony to the higher court. I would think that depending on what it is, if it is determined that the lower court is responsible for the loss of that transcription or testimony, it could be held against them and the appeal could be sustained. And they could say, do it over again and keep the record this time. I could also see a higher court saying, well, what did that particular witness testify to? And they could say, it's not really material. There were 4 other people that testified to the exact same thing. It's in the same vein, et cetera. I think, again, the court would have discretion. But in our system, so if you had a session trial and the presbytery was using its discretion on the appeal, it would be accountable because that appeal could be brought up by either side that lost to the General Assembly.
It's also worth noting at the end of that provision, there's a cost usually to doing this work, and the court assigns who pays for what for that transcription. Usually the higher court who's requesting the transcription might divvy up the cost for producing it between the parties. And so the church might pay for some, and the accused might pay for some, or the appellant and the appellee. It might be split up in different ways. And so there could be a cost to appealing, a physical cost, if you choose to appeal a trial.
And especially if you have to use, like I said, a court transcriber, that's expensive because they're spending time on a site. They're have a highly skilled way of working, and so that's definitely the case. Often, I would say usually there are 2 ways in which these costs are divided, either 50-50 or making the losing party pay.
$35.10 says that the records of a court or any part of them, whether original or transcribed, if regularly authenticated by the moderator and clerk or by either of them, shall be deemed good and sufficient evidence in every other court. So, Fred, you alluded to authenticating a moment ago. This would just be, maybe this is back into 35.9 a little bit, but so members of the court where the trial was held would need to go over the recording or the transcription, whatever it may have been, and say that it was what happened. And then somewhere or another, the court as a whole has to approve that transcription, whether by commission or a committee bringing it back to the whole. And that authenticated copy, then 35.10 is saying, is deemed good and sufficient evidence in every other court that may deal with this matter. Is that my understanding?
Yes.
Okay.
I think it actually is saying more than that, Ben.
Okay.
So in other words, if a court wants to submit minutes as evidence, if it's authenticated by the clerk, those minutes are deemed sufficient evidence.
Right.
Correspondence that's been received by a court. So it does exactly cover what you're talking about in terms of the transcript. But what it's saying is any official records of a court, you don't need to drag the clerk or the moderator in and say, what happened in the meeting? You can just have authenticated records, and they are deemed sufficient evidence.
Mm-hmm. Okay. So this is what, at the beginning of every presbytery meeting, when you approve the minutes of the previous meeting, that this is what they're talking about, are those regularly authenticated minutes?
Yes.
Okay. Good. Everybody all right? 35.11, in like manner, testimony taken by one court and regularly certified shall be received by every other court as no less valid than if it had been taken by itself.
I think this comes up in a very rare instance in which you might have a multi-jurisdictional case. Or this also goes with the provision that's elsewhere in the book about the provisions in all cases of process.
Yeah.
And one of those is that if a witness is at a distance, he can testify to another court. And so this provision ties in with that, so that you don't have to have somehow a member of the second court present at the first court to say, yeah, that this is actually what happened. You just deem it to be sufficient because it's in another ecclesiastical court.
And could you argue that a court using testimony taken by another court wouldn't be advised to argue something like, well, yeah, they may have said this, but they didn't say it to us, and so we're not gonna give it much weight. It's just as valid as if they had taken it themselves. It
yeah,
counts.
I think that's. Yeah. I think your point is well taken. That's why that language as no less valid. Mm-hmm. I think that actually restricts the ability of the court to say, yeah, but it was in another court, so we're not really going to believe it. The question would say, well, would you have believed it if it was said to you? And they say, yeah, well, then 3511 says you've got to take it with the same validity.
All right, guys, y'all all right? We got another big one, so if you need a break. 3512. When it is convenient for a court to have the whole or perhaps any part of the testimony in any particular case taken in its presence, a commission shall be appointed or coordinate court requested to take the testimony in question, which shall be considered as if taken in the presence of the court. Due notice of the commission or coordinate court or video conference and of the time and place of its meeting shall be given to the opposite party that he may have an opportunity of attending. If the accused shall desire on his part to take testimony at a distance for his own exculpation, he shall give notice to the court of the time and place at which it shall be taken, in order that a commission or coordinate court, as in the former case, may be appointed for the purpose. Testimony may be taken on written interrogatories by filing the same with the clerk of the court having jurisdiction of the case and giving 2 weeks' notice thereof to the adverse party, during which time he may file cross interrogatories if he desire it. Testimony shall then be taken by the commission or coordinate court in answer to the direct and cross interrogatories, if such are filed, and no notice be given of the time and place of taking the testimony. Listeners, I apologize for laughing through that. Scott literally got up and walked away, and it just tickled me. I think I blacked out halfway through that, so one of you guys still left on the screen is going to have to tell me what's happening in this section.
I won't go into the content, but I do think it's worth. No, it's really worth thinking through how fair this process is trying to be in terms of getting testimony, in terms of you being able to make your case that, you as a church member are not just going to be brought up by the session and say, hey, we know there's something wrong here and we can't prove it, but you're going to have to, we're going to admonish you. And you're like, hey, I didn't do anything. Like there's so many provisions that are made here that you can get your testimony, you can have your day in the church court, and you're going to make sure that you get testimony, even if it's by somebody that's far away and has to tell it to somebody other court, that's over there because you're in Atlanta and they're in, Pittsburgh or something like that. That was what I'm struck by in this entire thing, is just how many rights this gives to the congregant to say you're not going to be railroaded by the session. And if you think you are, appeal it to the presbytery. And there's just so many protections here. I just think that's, I'm actually encouraged by all the details that are here.
Fred, you want to help us understand what this is dealing with, this section? This,
again, it references back to the provisions for all cases of process. If you can't, if there's witnesses at a distance or there's a matter that's at a distance, it does allow for other ways to deal with this. And I think the principle is exactly what Jared is saying, which is to make it be as fair and as equitable as possible. And I don't think that's just for the parties. You have an instance where, for example, there's a case and there's someone who could testify to the matter who lives 2,000 miles away. Rather than make them at their own expense buy a plane ticket, take a day and a half off of work, fly to the court and do this, you can set up a commission, you could set up a video conference. And so what you get here is people are more likely to testify rather than just to ignore a summons or a citation, or to say, I'd love to come to your citation. I don't have $1,200 to fly and get a hotel room and come for this case. And so it allows these other, provisions to be dealt with in that way. And so, 3512, it references back not by cross-reference, but if you look at 32.8, 32.8 specifically says how you can take testimony. And 3512 has the exact same categories. Its own presence, a commission, a coordinate court, or a video conference. And so, they match together. Now, not in every instance is the BCO so explicitly cross-referenced, because as you all well know, our BCO is a 3-ring binder. And so it gets amended very often, guilty as charged. And so you have a book that has tons of authors. And so sometimes things get missed. But in this instance, I think there's a clear correlation.
Scott, you have one that's not in a 3-ring binder.
Yeah, and Fred's working it. I'm voting against no on everything, because my BCO will remain up to date until we change it. And so just vote no on everything at the assembly this year. Don't pass any of the items. Fail everything. My BCO shall be the standard.
3513. A member of the court shall not be disqualified from sitting as a judge by having given testimony in the case unless a party makes an objection and the court subsequently determines that such member should be disqualified. The elder against whom the objection has been made shall retain the right to vote in the determination of qualification. A member of the court who is the prosecutor in the case is disqualified from sitting as a judge. So there's certain circumstances in which a member of the court is not allowed to be a judge in the case. The first one being an exception for a man who is giving testimony and one of the parties requests that he not be sitting as a judge. I do find it interesting that he's allowed to vote in the determination of his own qualification. I mean, it makes sense, of course, but it's just, something happened that made that sentence be there, Yeah, and of course the prosecutor, yeah.
It's odd if it's a small session. If it's just like... It's just the pastor and like 2 elders. Anyway.
Yeah, there may not be a whole lot here to say. Fred's already spoken to some of these things. You alluded to 3513 earlier when we were dealing with, forgive me.
I think the main reason this provision is in here, there's 2 reasons. This was amended relatively recently. I drafted that last sentence. A member of the court who's a prosecutor in the case is disqualified from sitting as a judge. This was tweaked a bit, this chapter, by Howie Donahoe, Ruling Elder Donahoe, and myself, because you see things like a 4-member session. If there weren't a provision like this, a cynical view would be that if I were on trial, I would call every member of the session to testify to mundane matters like, am I a member of the church? Thank you, you're disqualified. Is the name of the church Christ Church? Thank you, you're disqualified. If there were no limitation. And so what this again gives you is the discretion of the court. So if it was a mundane matter that a member of the court was asked to testify to, he wouldn't be disqualified. However, I would say that a court would be wise if a member of the court was called upon to give significant substantive testimony, that he should probably be disqualified. That he was like the main witness for the prosecution. The court is handing really good grounds for appeal to the accused unless they disqualify that particular judge. And, the same is true, obviously, you can't be a prosecutor and the judge. That makes perfect sense. And so that was, I think, implied, and the book was amended to make it explicit.
So we keep going into 3514. An officer or private member of the church refusing to testify may be censured for contumacy. I think the big question here that I genuinely have is, why is refusal to testify considered a censurable offense?
Because you are called to testify as a witness through a citation from a court of the Presbyterian Church in America acting on behalf of the Lord Jesus Christ. And so you are given a citation to that, and to ignore that citation, this is a parallel. If you are given a subpoena in a civil or criminal court and you ignore that subpoena, there's a penalty for that, because the court needs the ability to compel testimony to come to the truth. This is a parallel here. We can't jail someone, we can't fine someone, but we can say you could be censured for contumacy. Now, that doesn't mean they're going to be excommunicated. They could be just admonished, because, of course, we don't know how important that testimony is. Mm-hmm. We don't know how difficult it would be to testify. But especially recalling what we've said earlier, if that testimony could be given over a video conference, it's not like you're really being put out.
Yeah. Mm-hmm. Indulge me for a minute. I think I know where this would go. But so we've established that you cannot compel the accused to testify. You can't compel a husband or a wife to testify against the other. Why is it that an officer or a private member of the church, based on 3514, can be compelled to testify in a court case?
I think the other two exceptions are long-standing common law exceptions. Yeah. That's, I think, the difference. And I think the other thing is there's no, how do I put this? There's no significant and inherent downside for a member or officer to testify. If you make the accused testify, he might have to incriminate himself. If you make a spouse testify, you might disturb their marriage. There's no similar, someone could be uncomfortable testifying against a friend, for example, but there's no parallel downside.
Yeah. Thank you. That's helpful.
When thinking about what are their jurisdiction limits for 3514? Is it just within your own wheelhouse, your own church or congregation? If it's at the local level, where are the bounds for this authority?
The authority to
cite, like if I cite pastor in the PCA down the street to come to be a witness, does he have to listen to it? Does he have to accept it?
I think he does, or he runs the risk of 3514. Now, you have to understand that in that instance, the court that's doing the citation can't censure that pastor. They'd have to report it to his court. And his court may say, no, we're not going to, because here you got your magic language, Ben. It's may, not shall.
Yeah. And because you're assuming all the other rules inside of this line of 3514.
That's correct.
So the only way to be censured for contumacy is to be charged and to have an indictment and to go through the whole process. And so it would just happen wherever it's appropriate for it to happen.
That's
if
correct.
It was going to. Yeah.
Yes.
Well, and then Scott, along with your question, I was thinking too, like Fred, we in an imaginary scenario, we said if a witness's testimony was lost and a higher court needed to hear it, they could ask them to come and appear, right? If parties agreed and stuff, if they refused to appear, that might be a matter of the higher court letting the lower court know that a church member refused to appear, and then letting the lower court deal with it on the flip side of it, as Scott was talking about teaching elder. Okay.
And so in this context, if it was a church member from another church, you would let that session know that they refused your summons.
That's correct. It would always be under the provisions for jurisdiction.
All right.
3515, if after trial, before any court, new testimony be discovered, which the accused believes important, it shall be his right to ask a new trial, and it shall be within the power of the court to grant his request. Well, I think my first question would be, have you ever heard of this happening?
I haven't personally experienced it, but you could see how something, could come to light. A witness could say, I'm sorry, I lied, I have new testimony, or physical evidence could be found, in which case, that could bring up an opportunity for new evidence to be heard. And again, this is solely within the court's discretion, because it doesn't have to give that. It just can't. Now, there's another provision in BCO 42.5 so this is not the only instance of new evidence. So let's say there were new evidence and the trial court refused to hear it and refused to grant a new trial. Under 42.5, it could be raised in an appeal. And the higher court could remand to the lower court to rehear the case, or it could hear the new evidence itself and proceed with the case. So again, there's you can't say this enough. There's a system of accountabilities built into Presbyterianism. And this is just another provision of it. So you're not compelling the lower court to do something, but you are saying you better be wise because you're accountable to other people. They're going to look over your actions. And if you make an unwise or wrong action, you're going to be called to account to it.
Yeah, I think Ramsey has a good instance in which this might happen. He says, even after technical acquittal, the accused may ask for a new trial in order to make his vindication more certain. So he's seeing a situation in which maybe it was dismissed on a technicality, but he's like, no, I want the full trial to have a full vindication. And the court may say, yeah, we're seeing that or something.
That's sharp.
Right.
How often, Fred, do people appeal to the SJC in this matter to get another hearing?
Based on new evidence?
Mm-hmm.
Not very often.
Is there sometimes confusion?
It's an error of process. I'm sorry, almost always it's an error of process. What?
Is there sometimes confusion where people think they can get another hearing, and so they submit something? Anything, just throw it at the wall, something will stick.
Right. Well, and there's actually a provision, in an appeal of sort of a lack of fairness, and people will, normally you want an irregularity, but there's also, mistake or injustice, a very broad category in 42.3, and to some people that means I didn't like the result. It obviously is a mistake because I didn't win. And so that's not a very good grounds for appeal. You may have an appeal because there may be evidence of irregularities or prejudice or whatever, and you should raise those. You should feel free to raise those. But just because you didn't win is not per se evidence of injustice or mistake.
Yeah. Okay, last one. 3516, if in the prosecution of an appeal, new evidence be offered, which in the judgment of the appellate court has an important bearing on the case, it shall be competent for that court to refer the case to the lower court for a new trial, or with the consent of parties to admit the evidence and proceed with the case. So similar to what we've just been talking about from 42.5. Any new stuff here to add, Fred or Jared or Scott?
I think this is just, it's very similar language.
Yeah.
3516 is really just referencing what I've just referenced in 42.5. It's a cross-reference in the main.
Good. Well, that's chapter 35 on evidence. I've got one question that mainly for Fred, but I do want to say first, you referred to earlier that there are many authors of the BCO because of the way that it works and functions. For our listeners and for anybody in the future that may listen, I don't know if y'all recognize what a value some of these episodes are, that we're preserving some of the comments from the authors themselves. And I'm not speaking tongue in cheek. I'm being very genuine. The value that this is, Fred, is of really can't be calculated. Thank you for all your time that you spend with us talking through these things. If you could leave, one general exhortation to elders about handling evidence, what would it be? You got any big picture points for them that we haven't hit on?
Yeah, I think be careful in preserving evidence and in making sure that it is all, brought to bear. Because remember, what the court is to do is not to see that one side or the other wins. This goes back to an episode you all had very early with current moderator Dowling. It's not so that justice is served. It's not so that the innocent are protected. Those are important principles. the purpose of discipline is overarchingly the glory of God. And so we want to make sure as courts that we're doing the right thing so that God is glorified. We realize that we're fallible, which is why we have a series of graded courts and appeals and complaints. That helps for accountability. But in the end, we can't be certain we come to the right decisions. But so what we should be doing is we should be doing everything in our power to make sure that we're having the right information in front of us so we can make those right decisions. The other thing that I would say is, and this is advice I give to every elder I can talk to, and that is, anytime in this process, especially here dealing with evidence and witnesses and when they testify and how long they testify, where you can obtain agreement between the parties in advance, you are doing yourself a favor by cutting off possible grounds for appeal. If the parties agree that, Joe shouldn't testify, then later on one of the parties can't complain that Joe didn't testify. And so I think that's very helpful. I think oftentimes in these instances, we try to be fast because we don't want to delay things. We don't want to get bogged down. We don't want to be in minutia. And my advice to courts is better to take a little bit longer in a trial and weighing evidence than to have ecclesiastical litigation. Ecclesiastical litigation lasts months and months and months and months. Try to do it right the first time through.
Scott or Jared, y'all have anything you want to add before we shut this thing down?
That was fun.
You may reply.
Today's sponsor.
Celsius.
Celsius.
Well, it's
healthy energy just for you.
Well, one thing I would say is just this seems a lot of technicalities, but it's a lot of this is preserving the rights of people during discipline. You're not gonna. This is to prevent you being railroaded and having just a session or a presbytery that's out to get you. This is so that when there's a sin that's accused, everything is fair. And so this is for our good, and it's good that we have this. So as much as you complain during your BCO exams and wonder why that blue book is on the shelf, this is for our good and our benefit.
That's right. Well, in honor of several friends that we have mentioned today on the show, as Howie and Steve and Guy would certainly say, this podcast is over. Thanks for joining us. Be sure to come back next time when we work through BCO 36 with Dr. Guy Waters. Thanks again to Fred for being here with us. Listeners, if you've enjoyed the show, consider following us on Twitter or Facebook at Polity Matters. Be sure to be subscribed to the show in your podcast app of choice. If you have questions or comments, you can contact us at politymattersfeedback@gmail.com. And there's a link below to go support our work. And while we bring swag to General Assembly that's available for everyone, there is going to be special swag available for supporters. So if you're interested in that, now's the time. Don't wait. Get on that train now so you don't miss what's coming. Thank you again for listening. Until next time, say goodbye, gentlemen.
Goodbye.
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 Y'all take care.